A very good evening to all. The topic of discussion today is lawyers as leaders in contemporary Indian scenario. And the basis of this topic is basically derived from two main reasons. One, the word law in lawyers, and the second is the great reformative British rule that we had in India, right? So they reformed the educational system and they even reformed the legislation, and that has led to this whole debate that is going on in India of what do you call a void in the legal system that we have. So first, moving to the concept of law, right? And for this, let's go back to the Arthashastra, where Kautilya mentions that Dandaniti forms the basis of administration. So taking that in contemporary scenario, we look at what does law affect in contemporary scenario. So while talking about law in general, law establishes an impact on an individual in day-to-day dealing. It has an effect on the general economics as well as the general welfare of the individual. For example, we have a technology like big data. So law impacts the application as well as the implication of the technology. So the technology, the data processors as well as the data subjects like us are all regulated by the law. But once we talk about the law, we should even talk about how the law should be. And that leads us to the second point. That is the great reformative rule of the Britishers that we had in India, right? And for that, the law should actually govern the society it deals with, or more predominantly the culture, right? And what is meant by culture? The word culture actually talks about and has been defined by Hofstede as a collective programming of the brain of one set of people that distinguishes them from the other set of people, right? So the law should govern a set of people having a certain set of programming in their brains, right? And he goes further to define two sets of societies. One, the collectivist setup, the other being the individualist setup. So the Western society is more based on an individualist setup. What is an individualist setup? Where the happiness of an individual is based on his personal happiness, right? So the Western society, the happiness of an individual is based predominantly on his own happiness. But in an Indian society, we are more towards the collectivist setup. And what is the collectivist setup? So my happiness might be even governed by my neighbor. So that is the collectivist setup that we live in, right? So what happened? The Britishers, in pursuance of unification of Indian laws, they codified the common laws. They initially started doing it, the codification in UK and US, where they failed miserably. So they did this experiment in India. So between 1860 to 1910, we had almost 15 private legislations passed. So with the contract law and the property law that we have all been passed in that era. Moving to the penal provision that was passed. So 1937, Lord Macaulay drafted the IPC, and he had to sit over it for 24 years before it was actually passed in 1960. And we are still dealing with the repercussions of it. One example of it being Section 377, as you might know. So this was the pre-independence era, or the colonial laws that happened, right? But why are we discussing it right now? It is because of the situation that took place after independence. And when I mention the fact after independence, we have to look into the fact what the Constitution said about it. So Article 372 Clause 1 talked about that the laws that existed shall continue to be in force until the legislature repeals them, right? Or amends them, right? So we all know how good the legislature is in India and what they did with the legislation. And what should have been the role of the lawyers? I'm not saying that there were laws which were not amended or there were not new laws that were brought on, right? So what we are discussing is how far the legislature did it and what should have been the role of the lawyering community in general, right? So what we see after independence has been the research basically in the public law domain, and that is directly related to the collective mindset that we have, because we are more related or we relate more to the public law atmosphere, like the constitutional laws and the different laws that we have, right? And we don't actually refer to the different private laws that we have. And the result of it being, the UK company law comes up, we have the Indian company law that is there, right? Even the IPR regime, a minister goes and signs TRIPS agreement, which has everything else apart from traditional knowledge, at the time when India had almost nothing apart from traditional knowledge. So what is left over is very little of ours. So the law that is governing India right now is not based on the culture that we live in. It is totally depending on a setup that is different from what is happening, right? So how it should be, and what should be the future roadmap. And when we talk about that, the question that should come up in our mind is the interdisciplinary or the transdisciplinary research that we should do, right? First, we need to establish how the law should be, especially in the private law domain, right? More moving forward from the public law domain that we are discussing. And then only we can establish how the law should be, because in earlier times what we had a very good village system that existed. And what about the village system? If there is a dispute, then it was solved by the elders of the family, then the elders of the village, then it went on to the courts of the kings, right? So we had a totally different mechanism. Right now we have around 2 crore pending cases at district court levels. Why? There might be reasons that might be projected that we are short of the judges that are there in the district courts. But believe you me, the total reason cannot be attributed to one main cause. You have to understand that the procedure that India is following is totally what we might not need to, because as a collective setup, we don't have that sort of mechanism to follow that. And that is why the law has been misused, right? And even the interpretation of the law. After independence, most of the work has been done on the interpretation of the law. What is needed to be questioned is, do we need the law in the first place? Or should the law be like it is in the first place? Then we should go into the interpretation of it, right? So in conclusion, what I would like to state over here is the discussion and the future roadmap should be, first, there should be a lot of thrust on the interdisciplinary as well as transdisciplinary research on how the law should be in India. Second, the role of lawyers in persuading the legislature, right? Because if the legislature sits over it, and if we can supply them with enough research material that we need a particular set of law, then why won't it go ahead? Because right now what is happening, they can refer to the law commission comes up with a report, and the legislature just sits over it as well, right? So there are many instances that are happening, but we need to focus on a lot of things in terms of research and the research that are contributed by the lawyering community, and not just interpret the law, but focus on how the law should be, right? And with this, I would like to conclude and state that for lawyers to be leaders, we first have to be social reformers. We need to reform our laws and put it in place for our own people, and not just interpret the law that has been laid by an individualistic mindset, because we don't belong to them, or we are totally different from what they are. Thank you so much. Jai Hind, Jai Bharat.